Hi everyone, Lynn Videcka here again. And in my jet lag, I omitted two very important acknowledgments this morning. So I asked Robert if I could just take a moment to, first of all, a wonderful, exciting, and timely event like this does not happen on its own. It takes a lot of hard work and dedication. So there are two groups that I want to acknowledge. First of all, the Planning Committee. Can you raise your hands, those of you who are on the Planning Committee? Let's give that committee a round of applause. Second of all, for the day itself and the lovely organization of the event, we have our development office to thank. So Susan Himley and all the development staff and other school staff, raise your hand. Thank you. Thank you, Robert.
So I want to thank Dr. Keating for that awesome talk. I think many of us afterward were saying, a lot of the stuff we think about and all, but he sort of put it together in a way that seemed to be easy to understand, but I know that we're all still thinking about it. We could probably call it a day and think the rest of the day about what he was talking about. But I also have three guests here who will be focusing on legal challenges that are associated with raising the age. And the three panelists are, first of all, and we'll go by the order that they're listed. Deborah LaBelle is an attorney and writer whose advocacy focuses on human rights of people in detention, the intersection of race and gender, and the rights of children in the criminal justice and education systems in the United States. In addition, in her private practice, Deborah is the director of the Juvenile Life Without Parole Initiative for the ACLU of Michigan and coordinator of Michigan's Juvenile Mitigation Access Committee. Her publications include Basic Decency, Protecting the Human Rights of Children and Ensuring Rights for All, Realizing Human Rights for Prisoners in Bringing Human Rights Home. Judge Frank Szymanski is judge at the Wayne County Third Circuit Court Juvenile Division and a judicial representative for the Wayne County School Justice Partnership. He has founded and sponsored a number of programs, including Youth Deterrent Program, Transcendental Meditation, Guitars Not Guns, Keep Kids in School, and Kids Are Reading Every Night. He recently published Identity Design, focused on the extent to which we are able to influence our own identity development. And Frank Vandervort is clinical professor at the University of Michigan Law School, where he co-founded and teaches the Juvenile Justice Clinic. His areas of research and his publications are in juvenile justice, child protection, and interdisciplinary practice. I had the pleasure of writing with Frank on culture as a defense in justice, right? So I want to give them a warm welcome, and then we'll go again by the order that they're listed in the program. So Deborah, great.
Thank you. I'm really happy to be here because I think that some of the origins of the work that's been done in the law is as a result of the deep collaboration that started to develop between schools of social work, policy, medicine, people doing race theory, and for us, I would look back at the 15 years ago where a group of us got together from the MacArthur Foundation, from the legal community, from the social work community, and we decided together from the faith community. It was a very intersectional group, and we decided together to tackle one area of law that had been disturbing many of us for different reasons for a long time. And in Michigan, it's encapsulated by a case that said, there's no constitutional right to be treated as a juvenile. And that was the law in many states. No constitutional right to be treated as a juvenile. Now, it's a particularly bizarre concept, So, in no other area, whether it be in race or in, identity based on nationality or gender, do you say, we're going to ignore who you are the essence of who you are, and we're going to treat you as something different. So we're going to say, yes, you're a child. You're definitely a child. We know you're a child, but we can treat you as if you're an adult. No one says to an individual, a woman, that we're going to treat you as if you're a man. We're going to ignore that status of your gender. And in fact, the Supreme Court in the Hamdi case, which was a very deep look at whether you could treat an individual who was an American citizen who had committed a terrorist act, could you therefore abandon the protections that we have for American citizens and treat you as a terrorist, a foreign national terrorist? And the court said no. Based on what you do, you cannot take away the essence of who you are. And that's what we've been doing forever with children. Based on what you do, we're going to conflate your identity and treat you as if you're an adult, which has been a particularly bizarre concept for many of us. So 15 years ago, we all got together and we said, we are going to challenge the nature. We're going to treat children as children. We're going to push that. We sat down with the people who were doing the Roper case, and who had started to develop getting rid of the death penalty, because we said we're going to take the harshest act that a child can do, the most egregious act that a child can do, and if we can convince the courts through a combination of social science and medicine and psychology and faith and parenting that a child is a child no matter what they do, and if we can get the U.S. Supreme Court to say child, not juvenile, not convict, not adolescent, but child, then we will be on our way. And we asked the Roper people who were doing the death penalty case, please don't give them life without parole, another human rights violation, as an alternative, which they agreed not to do. Then we took the life without parole cases as a concerted national effort up to the U.S. Supreme Court, and argued that a child who commits a rape is a child, and therefore you can't sentence them to life without parole in the Graham case. We then went back in Roper and said, here's homicide, children who commit homicide. You cannot treat them as comparable to adults. And I think that was the turning point for us when the Supreme Court, all but Justices Scalia, and Thomas never says anything, but all but Justice Scalia used the word child from the bench. They didn't use juvenile. They said, well, you can't do this to children, or what about the children? And it was uniformly, and we knew that once we had reclaimed back the child identity, that it becomes much more difficult for judges, for courts, for legislatures, we would hope, to treat children in the manner in which they're doing, and to ignore their status. And so what you had from the Supreme Court, in which we've all been building on since then, was not only the identity of a child, and we were greatly helped by the brain science, because I know that Dr. Keating said, he's not quite sure how it helped, but one of the things the brain science did, and it was no different than what we all knew as parents and as children ourselves, but it neutralized race. That's exactly what it did for the court. Because the treatment of our children, the elephant in the room, it's deeply racist. Whether it's because 99.9% of all of our prosecutors are white, and they cannot see that that's their child, so it's always the marginalization or other. It has a deep gender component in terms of the way we punish women and girls based on our preconceptions. All these things are embedded in there. But what the brain science did is it took that brain, which was no color at all except the blood cells, and it forced the court to walk off of issues of race. Now, what's interesting is even though the court certainly dealt with development in terms of sociological issues, they dealt with communities. They said, you have to, when looking at a child, you have to start looking at where they were raised. You have to look at how we failed them socially. You have to look at what their parents did to them. Did they have abuse? You have to look at their school systems. You have to look at that whole thing. And then they said you have to look at their development. and you have to look at how we failed them. Did we attempt to deal with them in terms of the criminal justice system? Did the juvenile justice system fail? They dealt with almost everything we talked about, except they stayed away from race. Absolutely no word from the U.S. Supreme Court on race. But I believe that the brain development helped us at least get them to where they were in terms of seeing all children and, the development in terms of the biology. One of the things that we are now facing in this state is, how do we pull 17-year-olds back into our child status? And, I remember it was about a year ago that we were in DC and we were talking to people from, various federal agencies, and no one could tell us how many 17-year-olds or how many children totally, but certainly not 17-year-olds who were in jails and prisons in this country. No one knew. They couldn't tell us about children in jails and prisons in this country. And someone from DOJ said, I think that it's like 1 million. And somebody else said, no, I think it's like 200,000. And because of the reporting by the states is some voluntary, some, oddly, and I know Joe Ryan will talk more about data, but even in Michigan, even in discussions today, someone said, well, it's about 700 right now, 17-year-olds in prison. Someone else said, no, we think it's 1,600. When I call the Department of Corrections, they say 50 yesterday, 50, that's all. So, we don't even know where our children are, which is a little frightening. And we don't know exactly where they're putting them, except that we do know from some of the deep harm that's going on inside. We represent a class of individuals who sued the Department of Corrections, it's been 4 years ago now, saying that you have children in your prisons, in your adult prisons, which Michigan does starting at age 13, and you're placing them in cells with adults, and you're putting them in solitary confinement, and you're tasering them, and these are deep violations of the Eighth Amendment, as well as the Civil Rights Act. At that time, the Prison Rape Elimination Act, the Federal Prison Rape Elimination Act, said you cannot, if you're going to continue to put children in adult prisons, which most of the states do not do anymore, but if you're going to continue to do this, then you have to separate them sight and sound from adults, which was not happening. And even when PREA came in 2012, the state itself was saying, well, we get what you're saying about children, but 17-year-olds are not children in our state. So they flung them out to every prison, and they were placed in cells with adults, irrespective of their age. And what we all know from culture and from basic understanding of some human nature happened. The 90% of the children, we have over 1,000 children in our class, 90% of them were sexually assaulted by adult male prisoners in the male prison. The other boys were sexually assaulted by custodial staff. And in the girls' prison, there's still assaults by custodial staff, despite great movement we've made in the women's prisons in this state. So, and they couldn't still tell us how many 17-year-olds were getting hurt. In addition, I have hundreds of children in the Michigan Department of Corrections who, when they were assaulted, were then put in solitary for their confinement, who spent up to 18 months in solitary confinement alone in cells, which I think that as social workers, you must know how destructive that would be, especially after a trauma that they suffered. So the destruction in terms of the conditions of children that are flowing from 17-year-olds not being considered as children in our systems is perpetuated by the fact that the way they're contained and the way that they are not addressed when they're let out. Some of the issues, and we have a deep need for data and resources in this area. We know, for example, that there are hundreds of 17-year-olds that go in that could actually complete their sentence before they're 21. There's no need for them to go into prison, and many of them have a minimum of a year sentence, so that if they could do their minimum, they could actually complete their sentence before they turn 18. But in Michigan, they go into the adult prisons and are deeply, deeply harmed. And the consequences of that as they come out and stumble, that is essentially our feeder program for the over-incarceration of people in the state of Michigan, youth. That's our feeder program, because once they stumble, it's very, very hard to stand straight when they get out. There are no resources for them out here, and they are now a felon. And the devastation of that following them for the rest of their lives, on top of every other dysfunction that they've come from, the trauma they suffer inside, it's really intolerable what we're doing to them. So the issues with regard to, there are legal challenges, it's true. There is a challenge on the equal protection, that what is the difference between a 17-year-old and a 16-year-old in terms of how they are treated differently in this system. There is an equal protection challenge that is being brought. What are the issues with regard to how they're treated in terms of the due process? The individual who has in this state the most highest ability to make these decisions without any judicial interaction is the legislature and the prosecutor. Right now, the prosecutors in this state have unfettered discretion as to who goes into the juvenile system and who goes into the adult system. When the decision is made, and I think that people up here will talk to it better, is that it's deeply embedded in terms of race and class. So in the poorer counties, it's much, and I've had judges speak very frankly about it. If I have a 17-year-old unarmed robbery, I'm going to put that kid in the adult prison, rather even in our county jails, because it saves county money. It saves county money, and I want the money saved for the kid who stays in the classroom and who goes to school and who is the good kid. Those are my terrible choices I have. We have 17-year-olds who have gone to jails for smoking because there's no juvenile access to doing this. We have 17-year-olds who are in jails for truancy because you have to go to school until you're 18. That's the law now. Because you're not responsible enough to decide that you should not go to school if you're under the age of 18. But if you're truant, if you don't go to school and you break that law, you can't go into the juvenile system if you're 17. So we have children in jails, 17-year-olds in jails for truancy and disobeying court orders to go back to school because they're now in contempt and they violated court orders, and they're in jails in this state for not going to school. So the push here for the legislation to do this, and I think everybody has acknowledged this, that it makes perfect sense that 17-year-olds are children in this state. For all the civil responsibilities in all civil areas, they're children, but for the criminal justice system, they're automatically adult, and they're paying a horrific price for it, as we all are. So the only issue here is that the counties say it will cost us more money. That's the only issue on the table, a redistribution of the costs from the state funds to the county, because they say taking care of our own children in the county will cost us more money. So, there is a legislative push to get this done, and it's bogged down right now in trying to analyze how do we do the redistribution of costs. And it has been done, as we've told, in everything but 5 states. All but 5 states now have figured out a way to make this work. And yet Michigan is still dragging their feet, and every day more 17-year-olds go into prison for charges in which they can be addressed in the juvenile system. Now, I don't know the juvenile system very well, and I know that it needs some fixes, and I'm sure others can speak to that. But I do know that it can't be as bad as the adult system. And I will leave this with one. I don't usually tell anecdote tales, but this is so reflective of it. And I've represented a child who was 17 who went into jail for 6 months, as the court understood that even though he'd had sex with a 15-year-old, that they'd been in the same class. And even though it was a crime, the judge said, I'm going to put you in the jail for 6 months to 8 months because I have to punish you as an adult. So in the jail, he was put with adults, and they sharpened his toothbrush down to a point because he was pushed for sex. In the jail, he had a weapon, which was caught on camera in the corner in the cell, and so he got a 1 to 5 sentence in the adult prison for a weapon in the jail. When he was in the prison, he was raped repeatedly over a period of 5 months because he was placed in cells with adults. He was still 17. When he refused to leave his cell one day, he did a cell extraction, which is gassing to bring a kid out of a cell. He wouldn't leave because of the danger. He fought, and in fighting the guard, he struck out and hit one of the officers in the arm, which is an assault on a staff. That's 3. That's life without parole. So we have taken a child that could have easily been dealt with in the community in some kind of restorative justice thing, and we now have, when you have 3 felonies, you are then eligible for life without parole. So I urge all of us to work harder with our legislators and in the legal system, and to really alter this and to do it as quickly as we can. Thank you.
All right, so yes, I'm Judge Frank Szymanski, and I work in the juvenile court in Detroit, and very sad to hear about that anecdote. I'll just tell you, so juvenile court, what do we deal with? Well, just this month, I've dealt with an internet scheme to sell a baby, a first-degree murder where a 15-year-old shot and killed someone over a $30 drug debt, and a father who fathered a child with his daughter. So the problems are deep, and there are a number of us judges that, as we see these problems, we feel that I really feel like we see the deepest problems that our society has, and we're welcome to work with you on solutions, because that's what we need. And we're talking about raise the age here. I'd like to start with the big picture and some numbers that some of you are sadly familiar with. So what if there was a country that had 5% of the world's population and 25% of the world's prison population? Now, statisticians would call that an anomaly. I call it a tragedy, and I think you know where I'm going with this. We're talking about the United States of America. And I know we've all heard this, and I'll let you fill in the blank. What do we call ourselves? The land of the free. Well, when you think about those kinds of numbers, you realize that calling ourselves the land of the free is really nothing more than a hollow boast. But maybe there's an explanation for this, right? Maybe, are we the most evil people that ever lived? Well, there you go. Well, I can leave now then. No, I don't believe that, and I don't believe you do either. The problem is we've got some issues with our justice system. And we have a prison industry here, and it's like the dairy industry, and the meat industry, and the pharmacy industry, and the gun industry. What do they all have in common? They love to throw their money around and lobby and throw their money around on things that are going to allow them to make more money. And if you look at what's happening with campaign financing, and we just, the legislator just passed another law I read about yesterday, makes it even less transparent where money comes in judicial and in legislative campaigns. It's frustrating. But these businesses, okay, so what do we get from these? Drink milk, eat your cheese every day. If you're in pain, make sure you take these pills every day. And if we want our streets safe, we need to make sure that everyone can have a gun that can kill 50 people in 60 seconds. And what about the prison industry? They've got their solution for our deepest problems. Drug addiction. Lock them up. Mental illness. Lock them up. If we lock up as many people as we can for as long as we can, we'll solve these problems. Does that sound like a solution? I don't think so. And let's forget about real rehabilitation, because that's just not good for the bottom line for the prison industry. Brian Stevenson, Dr. Sari told me he was here last year, who wrote that fabulous book, Just Mercy. And he mentions in that book, from I think it was 1990 to 2005, here in the United States, we were opening a new prison every 10 days. Wow, that's an obscene amount of growth for an industry that really we shouldn't be wanting to encourage. So we've been given basically a false narrative as I see it. We've been told that there is a burgeoning class of sociopaths, teenage sociopaths, that we need to lock up in order to address their evil and wicked ways. And it's really just not true. I can tell you. Look, I'm in Detroit, all right? So I'm ground zero for juvenile issues. And I've been there 10 years on that bench. And yeah, I've had a couple kids that might fit that category. A couple in the hundreds or thousands of kids that I've dealt with. So we don't need to be treating 17-year-olds as adults. And I think about school issues, and if I get a chance to maybe come back, I'll spend time talking to you about school issues. I was a teacher before I went on the bench. But we basically we've been worshiping at the altar of zero tolerance. Zero tolerance is the answer, right? And the research is in from organizations like the American Psychology Association that tell us, zero tolerance, it really, when you look at it and the results, it's really zero intelligence. Because I don't have much time here, so I'm gonna spoon feed you the answers to these next three questions. Are no, no, and hell no. Because the research tells us, does zero tolerance, does it improve academic performance? No. Does it improve school culture and discipline? No. And does it make schools safer? Hell no, it doesn't. So we've adopted these policies and they're just not working. We've got to get away from them. And when you think about it, treating a 17-year-old as an adult, it's just another form of zero tolerance. Because we're saying, well, we can't treat you as a child anymore. And Dr. Keating gave us all the science on that. And certainly that's all there. And you know, when you think about these kids that come into our courtrooms, I mean, we're talking about the traumatized, the victimized, the marginalized. These are the kids that are being locked up in these prisons. And these are kids that basically get into trouble because they don't know who their dad is, and their mother is at work, or she's strung out, or these are the issues. You know, we have to ask, when these kids come into my courtroom, I don't just ask, well, what have they done? What has been done to them? That's the question we have to start with. And most of them have suffered these traumatic experiences. That's the whole reason for a juvenile court. You know, if we're not going to move this age to 18, why don't we just get rid of the whole damn juvenile court to begin with? So, do you know when 44% of juvenile crime takes place? Here's a statistic for you. During the school day. Does that tell you that all these suspension first policies should go out the window? Absolutely. Now, I ask you, and it looks like we've got a few of you here that survived your teen years. Am I right? All right. How many of you, we can just raise our hand, how many of us did the stupidest, the most dangerous, the riskiest things in our lives when we were teenagers? Just raise your hand. Well, there you go. There you go. And how about when we were 17? When we were 17, right? That's what the research, I mean, it's common sense. So we really need to really need to raise the age here. And you know, for me, everything comes down to, and Attorney LaBelle alluded to this, and I couldn't agree more. You know, everything in my book, when I think about these kids in my courtroom, everything comes down to one thing: identity. How do we, and how do the young people in our courtroom, how do we see ourselves? Everything else is going to flow from that, right? So, I mean, after 10 years of listening to the kinds of things that I listened to in my courtroom, I wanted to develop what I could in terms of the best advice that I could offer. And I wrote, I don't have a slide, I'll just hold it up here. But this is my book, Identity Design, and it's a couple hundred pages of my best take on. And a lot of it is things that I learned working with juveniles, working with children in my court, and asking them, well, what did you do? What were you thinking? Why did you do this? And then hearing what they said. And I just did this week. And, you know, when somebody's ready to go home, you know, I did have to send them to a placement. It's a juvenile placement. It is very different from, and I go to these places myself, so I know where I'm sending these kids if I have to. We try to avoid it, but we go and we have to, as I say, think about, well, how is everything that we're doing impacting their identity? And we heard about neuroplasticity. I'm a big believer. You know, in my mind, my brain is still developing, and we all should be. We all can still be learning, right? So, and when I do these presentations on I'll give you a little example how I view this. And this is the first time I did this. I was at JDF in front of 120 juveniles. But so, and I tell people, I say, you got to think about things a certain way. So I've got here a little rear view mirror, right? And if you just imagine, okay, yourself, and if you're driving your car and you have your rear view mirror and you look in the mirror, all right, so I can see the wall, right? And I ask people, so where is everything that you see in that mirror? Where is it? Behind you, right. And where is everything that you've ever done? It's behind you. And everything you've ever said, or everything that's ever been said to you, it's behind you. And yet, we tend to choose to let that define us. And our past only defines us if we choose to let it define us. So what I tell people is one of the first lies of identity is that you are what you've done. And that's a lie. It may be a reflection, what you've done may be a reflection of who you were, but it's only who you are if you choose to define yourself that way. And that's why we have a juvenile court, and that's why we work to change and transform people. I like to refer to it as the court of transformation. And I'm going to give you a little example right now of some people who went through a little older transformation. I've got a little film clip, and I'm going to offer you, I'm going to try to kill two birds with one stone here. So I'm going to show you an example of how individuals can move on and not let their past define them, even when they've committed some of the most serious crimes we could think of. And I'm going to introduce you to a program that if you know of any at-risk youth that might benefit from something like this, you can get in touch with me. I'll get you the information. They can attend this program. We have a sister program for women. It's called Girls on the Rise. This program is called the Youth Deterrent Program. It's active in Detroit. I'm the judicial sponsor for it. And there's a brother program, I guess we'll call it. There's a prison near Muskegon that's starting this. And I'd like to see this grow, but it's just a 3-minute clip, so we're going to play that for you and let you see that right now. We don't have any volume. We have... I'll go back. It's down to about, okay, I've got it up all the way now. We have it now? Maybe we can let Frank go and see if they can work out. Do we think we have it, or you want to bring a tech person in? Why don't you? I just turned it up there. Oh, you got it now? Okay, so we can run it? All right. Okay, let's see if it'll go from here. It's just a short clip, it's just a couple minutes.
Rashad Odin, locked up for 15 years. Dwayne Witherspoon.
Little Ernest Timothy Smithfield Sr.
James Hill L. I don't have an out date, so I'm scheduled to die here.
Michael 2X Tubbs.
Daryl Woods, sentenced to life without parole. We are the Youth Deterrent Program at the Detroit Reentry Center. We are here to transform the lives of our young people and give them a sense of identity and purpose.
I'm Judge Frank Szymanski. I work in the juvenile court in Detroit, Michigan. We have 2.5 million adults under direct supervision of federal or state corrections officers. Right now, 1 in 3 black males is basically on course to spend time in an adult prison. It's time for us to just stop building prisons and start talking to young people and start giving them the kind of information that can help them to make the right choices.
They are glorifying the scared straight movement, and our children don't need no one threatening them, cussing them out. They need more love in their life, and so we would like to see the programs spread it and this message of love spread it throughout the country.
We try to let them know they are great beyond what they ever imagined. It's just that they need a time to understand who they really are and what they really want to be.
And we understand that they're young, but they're witty and they're wise. And they recognize real from fictitious. They know when something is staged. So we just give them us.
The majority of their experiences, the things that they go through, I've already experienced before. We all have experienced them.
And most of the group that doesn't have a male in their life that they trust.
Many of them think they have to go rob and steal or sell drugs to get the money. What we teach them in the Youth Deterrent Program is there's ways that you can make money and stay out of prison or not get hurt.
They do listen to us because we've been there. We know what they're going through. We feel their pain, you know.
And when you really listen to the youth, they'll tell you what their problem is, and that's half of solving it, knowing what the problem is.
I'd like to see a program like this adopted at facilities across the country.
I want to see more people be involved with it. I want to see more children being helped.
It's part of the service I believe that I owe the community.
I feel like when I talk to a youth, it's my chance to help save them because I have so many regrets of not saving myself.
This is probably the most fulfilling thing that I've done. You reach a certain part of your own humanity while you're trying to give yourself.
I have 2, 4, 6, and these aren't even all of them, but 6 father figures. I came here, once a month to visit them, but they still stayed in my heart. With a collaborative effort, we are going to change the world. Every day, every hour, every second.
This is a life-saving program. This is something that we pour our soul into.
And we understand the notion that no one cares how much you know until they know how much you care. And so we want them to know that we honestly and genuinely care for them.
All right, so that is the Youth Deterrent Program. It's in Detroit. I actually have we have some flyers and I have some consent forms if you want to see me during the day. And then, as I say, we have a sister program. I've attended that also. It's at Huron Valley, and it's for girls. So, I mean, this is an example of what people can do and how they can change. And most of these young, well, they're not young anymore, these gentlemen, I call, you spend some time around these guys, they're phenomenal. And they really are on a mission. I like to tell people, we're all here to save the world, and we just have to find our part. So let's do it. All right, I'm going to turn it over to Mr. Vandervort. Thank you.
Thank you. As I thought about our efforts in Michigan to raise the age, I think it's helpful to think about the age limits that we're talking about in an historical context so that we understand kind of what it is that we're trying to change. The effort that we're working on has very long historical roots. There's always been a kind of, I call it a border war between treating children as children and treating children as adults. So when you start to think about it across history, if you think about the American legal system, for those of you who don't know much about how we got the legal system we got, we basically inherited our legal system from England, way back when we became a country, and even before. So before the middle 1800s, before around 1825, the kids were simply treated as adults. You were charged as an adult if you committed a crime, you were tried as an adult, you were convicted as an adult, and you were sentenced just like an adult. So we've, in this country we have a long history of exacting horrific punishments on children. Children have been executed. Children as young as 10 years old were executed in this country in our history. Children 12, 13 years old, fairly large numbers of them were executed in the 1800s. In the mid-1800s, beginning in about 1825 to about 1850, people started to understand that kids were different. So this idea that we come about today, Roper versus Simmons, that children are different, Miller versus Alabama, children are different than adults. That actually took root in the middle 1800s with a movement called the House of Refuge movement. So we tried to move children. Children were being sent to prisons with adults. What Deborah LaBelle described this young man that went into the prison system at 17 for skipping school was routine practice in the mid-1800s. And people who worked in there, mostly social workers, thank you all very much, mostly social workers, began to see that kids ought not to be in that system, that there has to be something different for children because children are different. So they started a House of Refuge movement, which was a sort of juvenile housing within the adult prison system, or what was then the only prison system. So in the Michigan, in the 1850s, Michigan developed a House of Refuge in Lansing. It came to be known as an industrial school. So that term's something that you may have heard about. So kids were separated within the prison system. And then in 1893, the United States Supreme Court decided a case called United States versus Allen, in which a child committed a homicide and was tried. And the question before the court was whether he could be held criminally responsible, and the court adopted this idea that had grown up over time. Because we were charging kids, this idea of an infancy defense grew up in the law. And this idea of infancy was children under 7 could not form the criminal intent to commit a crime. They couldn't form what we call in the law mens rea. They didn't intend to commit crimes. Kids between 7 and 14 were presumptively not able to develop the criminal intent to commit crimes. But a prosecutor might show, and it was a factual determination to be made by a jury, that a particular kid between 7 and 14 could in fact and did form a criminal intent. So you had juries deciding, first of all, whether there was, the kid intended to commit a crime, and if so, were they guilty of what they were charged with. So we had this notion of infancy defense. In 1893, the United States Supreme Court adopted the infancy defense explicitly in Allen, and in fact sort of blurred the margins a little bit and said, we know Mr. Allen's 15, but that's pretty close to 14, so maybe we should decide whether he can commit a crime or not, right? So what Professor Keating was talking about earlier, the idea of development and its impact on the criminal justice system and punishment, that also has very long roots, right? So at least by the turn of the 20th century, the legal system in this country had begun to think about how development impacts legal decision making. And then, of course, in 1899 in Chicago, we get the first juvenile court, and that's all kind of put on hold in some sense, right? Within about 15 or 20 years, all of the states, except for 2, have separate juvenile systems. The original Juvenile Court Act in Illinois established 16 as the jurisdictional age. So if you were 16 in Illinois in 1899 and committed a crime, you still went to adult court. If you were 17, you still went to adult court. And once you were in court, jurisdictionally, if you were in the juvenile court, right, so if you're 15 in 1899 and you commit a crime in Chicago, you go to the juvenile court, but the juvenile court now has jurisdiction over you until you're 21. So you kind of see the broad outline of how even more than 100 years ago, we understood that there was something different about kids in that late kind of adolescent moving into their 20s. So the system recognized that at some sort of an intuitive or behavioral observational kind of level. Michigan got its first juvenile court in 1906, and its juvenile code was revised substantially in 1931 and then again in 1944. And the idea of a 17-year 17-year-old going to the adult system, some people think that's a remnant of the 1980s and 1990s counter-reformation in juvenile justice. It is not. That's been an element of Michigan law at least since 1944. So for all of that time, we have sent 17-year-olds to our adult system in this state. So then the next big milestone in juvenile justice is, of course, 1967, right? In re Galt is decided, the Supreme Court says we have to bring constitutional legitimacy to what's going on in juvenile court. Between the time of the establishment of the juvenile court in 1967, juvenile court was kind of the Wild West. Judges did whatever they wanted to do. We could, Judge Szymanski, if he were sitting in Wayne County in 1940, could say, here's Johnny. Johnny needs some guidance. Well, there's Joe Ryan. Joe, I'm sending Johnny to your house. You'll take care of him, right? That's right, Joe? You'll take care of Johnny? Yeah. Right, so there you go, right? No legal authority to do that other than Judge Szymanski is worried about this kid and can do whatever the hell he wants with him. And so the court said, you got to have some constitutional consistency, some constitutional validity to this process. Well, think about what was going on in 1967. For those of you who might be watching the Ken Burns series that's been going on the last couple of weeks, right? 1,000 people in the street, right? Everybody was protesting. There was, the summer of love, right? Drugs on the rise, right? Nixon is president. What's he running on? A law and order campaign. So 1967, we get Galt. And the attitude becomes, well, if those little bastards want due process, then they're going to get punished. What you get for your due process and your fair treatment is you get punishment. And so we saw that immediately in the aftermath of Galt, right? By 1972, New York enacts the Rockefeller drug laws, part of which is sending more children to the adult system and making it easier. There was a very famous case in New York, a kid named Willie Bosket, who had committed a murder as a juvenile, went to the juvenile system, got out and killed a police officer. And, this was a kind of, political bandwagon to then make it harder and to make it easier to send more kids and to treat children more harshly in the juvenile justice system. So in 1988 then, right, by 1988, some of the stuff that was going on in the late 60s and early 70s dies down, but then we get the drug epidemic, right? We get crack. So we get, crazy stories out of places like Detroit and Chicago and Los Angeles about children, right? In Detroit, we had Young Boys Incorporated. We had an actual Amway-type pyramid scheme where the bottom of the pyramid was a bunch of 12, 13, 14-year-old kids, mostly boys, selling drugs, selling crack cocaine, and carrying guns. So what happens? The homicide rate goes up 200%. We can talk about the statistics of that. If you have one homicide, that's 100%. If you have two, you've gone up to 100%, right? So homicide goes up 200%. Reporting on homicides on the 6 o'clock news and the Detroit Free Press and so forth goes up 600%. So the perception is, oh my God, right? And then you've got these geniuses like some guy from Princeton, and you got some guy from New York University who's going around the country talking about super predators on all the morning news shows, right? So everybody is reading in the newspaper every morning. They're seeing on the 6 o'clock news and the 11 o'clock news, and then these geniuses, saying, oh, we've got this whole generation of super predators who are going to, it's going to be an onslaught. It's going to be a bloodbath. We've got to do something. So in 1988, Michigan makes it easier to send more kids to the adult system. In 1996, by 1996, the homicide rates have dropping precipitously. Violent crime is already by juveniles is on the decline. We get a second wave of that, so that now in Michigan, in 1996, any child of any age can be tried as an adult for any crime. There's a way to do that. And we get an 11-year-old charged with first-degree murder, and tried as an adult. An 11-year-old, emotionally impaired, probably developmentally disabled little boy who in order to convict him, the appellate courts in Michigan first had to say that he could make a knowing and intelligent waiver of his Miranda warnings and voluntarily make admissions of his guilt to the police. That case is kind of famous, but what we don't know is that there's an unpublished Court of Appeals case in Michigan that says that an 8-year-old can be taken from his mom and dad into a police interrogation room and make a voluntary and knowing confession by waiving his Miranda warnings. We just had a case before the U.S. Supreme Court last year in which a 10-year-old, it was held in California, made a knowing and intentional waiver of his Miranda warnings, admitted to killing his abusive neo-Nazi father, shooting him in the head after the father threatened to burn the house down and kill everybody in the house. The kid shoots him, confesses, and is sentenced to 40 years in prison. So we got a 10-year-old sentenced to 40 years in prison. In 1988, the United States Supreme Court decides a case called Thompson versus Oklahoma, in which it says you cannot execute children who are 15 or younger when they commit their crime. The next year in 1989, they decide Thompson versus Oklahoma, in which they decide you can execute 16-year-olds. So we have 16-year-olds being executed, and we have a genius down in Texas who introduces legislation to say, if you commit a certain kind of crime and you kill someone when you're 10 years old, you can be sentenced to death, but the death penalty can't be carried out till you're 16. So that's the kind of atmosphere we were in the United States and in this country. In this state, I went up to the legislature in 1996 to oppose that legislation, and it was a little bit like a bidding war, where the Democrats sat on one side of the table and the Republicans sat on the other side of the table, and they were trying to figure out who could be harsher on children. And they were passing things that they had no idea what they were passing, and they had no idea what the implications would be. And what the implications are, of course, is hundreds and hundreds of children going into the adult criminal justice system. Only in 2005 do we start to see some sanity return to the system. Roper versus Simmons, the Supreme Court says you can't execute children under 18 years of age, for all the reasons that Deborah, LaBelle, and that Dr. Keating were talking about this morning. We get Graham versus Florida in 2010, says you can't sentence children to life without parole for non-homicide offenses. And then we get a case called JDB versus North Carolina, which says, you have to take age into consideration when you're deciding whether a child can make knowing and intelligent waivers of their Miranda rights, or whether they have to be Mirandized, whether they're in custody. And then in 2012, we get Miller versus Alabama, which says no mandatory life without parole sentences. And that opens the question about whether Miller is viable. I question whether it is. The fundamental problem with Miller, as I see it, is by definition, you've got a homicide case. So by definition, you've got bad facts. And I think our experience is going to show us, I think it has shown us, and I think it's going to continue to show us, that judges simply cannot set that aside and then decide that very, very small number of children who should be eligible for life without parole. I think it's clear now, and I think it's going to become even clearer, that we have to simply say, you cannot sentence children to life without parole. If we're going to stop that process, because I don't think judges are going to be able to separate themselves, separate their political ambitions, separate the awfulness of some of the facts of the cases from the decision that has to be made. So that's how we got here. And so that's the long history that we're up against as we think about and as we move to try to change the age limit for juvenile court. Two things important about this. There's always been this sort of border war about how old kids are. Despite the fact that we've had a juvenile court, we've always had kids tried as adults, always sent to the adult system, sometimes sentenced to the harshest penalties that the law knows. And there's always been an absurdist element to some of what happens in the juvenile court system in dealing with kids in the criminal law. The case that Deborah LaBelle spoke about, where I think if you went out in the community and you said, do you think it makes sense to send a 17-year-old who skipped school to jail for 6 months? People would scratch their head and say, that doesn't make any sense to me at all. There has to be a better way. And then you get cases like Gerald Galt, right? Gerald Galt made a prank phone call. Abe Fortas, in writing the Galt decision for the U.S. Supreme Court, described the phone call as being of the irritatingly offensive adolescent sex variety. So I'll stop there and let you think about that for just a second, right? The irritatingly offensive adolescent sex variety phone call to a neighbor lady for which he was sent to prison for 6 years. Ouch. Right? It's absurd. So there's always an absurd element to our dealing with this. So I'm happy to stop there, and I'll be interested in questions, comments, and discussion. Thank you.
Thank you very much, all of you. It was very, very fascinating, at least for me. So what we want to do is open it up, and then at some point I'll move, and then you're welcome to come up here, Dr. Keating, so we can include you as well. But for now, does anybody have any questions for any of our panelists here? Okay.
Hi, I'm Carolyn Growie, and I work with individuals with disabilities. And something that you haven't mentioned is about all the students who may have had something going on in their life that may have been not processed properly in the school systems related to disability or needs, who even in some of those confessions may not have even understood, forget that they were young, add on top of that they may have a disability. I'm wondering if there's any statistical data that you know of the number of students with disabilities who are ending up in our systems as well, who then are now in this 40-year cycle that we're talking about.
Yeah, well, I know for in terms of in the juvenile court, in the juvenile system, not juveniles in the adult system, in the juvenile system, about 3/4 of those kids have diagnosable mental health problems. Almost every kid. So part of what Dr. Keating was talking about is, there's a developmentally normative element of this. We all raised our hands when we were asked, the stupid things we did as kids. So there's a developmentally normative aspect of this. But the more serious the offense, the more likely you have somebody who has a disability, a kid who isn't functioning, in a kind of within a normal range of functioning, even for a child that age. One of the things that the Miller case talks about is you got to look at the kid's history and what we know about the kids who commit the kind of catastrophic violence that gets you into a life without parole kind of situation, is that every one of those kids has a horrific experience as a young child, whether it's problems with their attachment in early childhood, whether it's being the victims of abuse or neglect, drug-addicted parents, et cetera, et cetera. And those manifest themselves in school failure, in disability, in a whole host of problems that are all diagnosable and that usually haven't been diagnosed or sometimes have simply been ignored.
I would just note that, starting 3 years ago, because we had this class of youth who were in adult prisons, we did a sort of 3-tiered questionnaire and survey with regard to those. It was about 1,000 youth, and asked them, we were looking at whether they were in special ed in school at the time, and 38% of the kids had, and that's clearly not all of them. That's a floor, not the ceiling. But 38% were in special ed classes at school before they committed the offense that got them into prison. So I think, it's a really, significant number of the population.
Yeah, just one other thing. It's a major issue with kids that we have in juvenile court. There are some groups. We have the Student Advocacy Center. We have the Michigan Children's Law Center has an educational advocacy unit. So there are some groups that advocate, because a lot of times these kids are special needs, but they're not getting the services they're entitled to.
So we have some groups, and if anybody needs help with that, reach out to me, and I'll be glad to connect you with that. It's a big issue.
Every county in our state, there's representation from Centers for Independent Living, which is another resource. It's a no-cost resource to help individuals get the services that they need, whether they're youth or adults. The last piece I just wanted to say on that, one of the things that we find is that social workers aren't trained, psychologists aren't trained, lawmakers aren't trained, judges aren't trained, lawyers in general aren't trained on disability issues. So we kind of scave over it, and then it doesn't get focused on until it's already too late.
I would note, just to follow up on that, when we asked whether any of their lawyers or judges, was a follow-up question, addressed any of their disabilities at the time of their sentencing, and it was 100% no.
Hi, I just wanted to know if, is there a bill in the Michigan legislature that a number or something that if we can talk to our state legislator as well, the Senate as well as I want to do that as quickly as possible.
I think there's actually in your blue folder that you should have gotten when you came in, I believe that there's a list of, I think there's a whole package of bills dealing with this. And it's, if you look in there, I think there's a spreadsheet with that information on there. So feel free to call your legislators and express your interest in having them take those bills up and take them seriously.
Great. Good morning. My name's Abigail Eiler. I just have a real quick question. So those youth that have already been, it's been determined that they will be tried as adults, are meeting with prosecutors, are talking to judges, and are requesting that their sentences be, there be a disparity there, because their gangs do not exist in the criminal justice system. So they're asking for harsher penalties by saying, I'm making the decision that I want to live. If you send me back home, I will be killed. And so even though I've taken the position and I agree with raising the age, for those that are currently being faced with this hardship of being sentenced as adults, I'm wondering what your thoughts are related to someone saying, I want a steeper sentence. And we know about neuroscience, right, and people being able to make decisions at young ages and the impact of that. But just getting your all feedback on what does that mean, what does that look like, and is this something that should be considered when a child says, I want to live, and so please give me a harsher penalty.
Saying that a child
into their communities. Yes, so if they go home into their communities, there are opposing gangs that will seek them out to murder them. And so because of that, if those gangs are not recognized in the criminal justice system, they're saying, I'll be able to live, so give me a sentence in which I can live.
First, I don't know. Representing youth who come in and get gang designation or don't, know from the community. I mean, if you're talking about the prison, it's pretty well, people inside know a lot about what's happening in the community. So I don't think it's any safer, and, representing a kid who just got stabbed 21 times when he went in because he had some gang involvement and somebody knew somebody, and I don't think first that that's a choice for life inside, but at all. And I don't think that that's a basis for punishment. And if we can't help a child do any better than to say we're going to incarcerate you because you're in danger in your community, I don't think that's a viable alternative. I don't know who's working in the community you're talking about, who's working on the gang work, stuff. But, there certainly are, in some communities, some people doing some deep work with regard to youth in that area. And, whether you're talking about getting a kid out to a Delancey Center or something else, or that just can't be the viable alternative.
Right, and certainly in the juvenile system, the court has the authority to place a child with a relative or some other place where they would be, if their home community is problematic, then there are other options that they would have. I would just say that in Miller versus Alabama, the Supreme Court talked a little bit about this, where kids don't have the capacity to extract themselves from really dangerous situations within their families or within the broader community, and that's something that the court should take into consideration, not to increase sentences, but to mitigate sentence. And there should be a plan made for that young person that will keep them safe, whether that's going, to be placed with a relative or, some other programming. If our system if that's the best our system could do, is to say, I'm not safe in my home community, send me to prison for more decades, that would be an absurd outcome, right? I mean, that's ridiculous. So we would need to, as a community, we have an obligation, I think, to develop programming to keep children like that safe.
My name's Ian McGregor, and you might notice I'm white. And nobody has mentioned racism and the part racism is playing in this whole situation. And I'm wondering if someone would like to address that.
Well, you can't talk about juvenile justice in this country without dealing with race and class. I think Deborah touched on that just a little bit, but it pervades the system. We had a community group here in Ann Arbor that contacted me, and they wanted to do some court observation, and they called me back a while later and said, "Where are the white kids? Why aren't there ever any white?" In this, I'm very harsh on this particular community because we sit here in Ann Arbor, which has this reputation as being a bastion of liberalism and progression and all of that. That's nonsense in terms of our juvenile justice system. Like, you go and sit in our juvenile justice system in this county, and it is black kid after black kid after black kid. An occasional white kid. There's almost a pipeline from certain schools in this county to our juvenile court, and there are schools, apparently there are no crimes that ever take place at Pioneer High School. Very, very rarely is there one at Huron High School, but there are daily crimes in the Ypsilanti High School, in Lincoln High School, and there's practically a bus between those schools and the juvenile court. When you start, it is absurd. I don't know if they intend, who the people who make the choices and decisions about charging kids are intentionally doing something, but the kids who are ending up in court, it is hugely disproportionate in this allegedly progressive community, black kids and poor kids. And that's just the way it is. You occasionally see a white kid, you occasionally see a kid who's not from an impoverished family, but it is extremely rare in my experience.
It's a big problem.
And I worked in Wayne County for years, and that's a system that's 80 or 90% African American kids being brought in. And it's almost all boys. There's a growing number of girls, but by and large, boys.
It is a major, major issue in Detroit, and I've done presentations with Dr. Rita Cameron Wedding, who does her expertise is dealing with the issue of implicit bias. And the fact is, we've got a black prosecutor in Wayne County. We've got Kim Worthy. And I was just talking to an attorney yesterday about an issue where two defendants, one with a much less egregious background, but who was black, and one with a much higher record of criminal, a worse criminal record. The white guy got the deal just like that. She said she had to pull teeth to get the same treatment for her black defendant. So there is no question. And the thing is, and I think Dr. Cameron Wedding is right about this. People aren't intentionally trying to be racist. It's just ingrained. She shows us a film clip, and it blew my mind. She showed me this film clip where they took
young children and they asked them, and they had these dolls. They had a white, this is on the internet, you can go search it up. White dolls and black dolls. Even the black kids, when they're asked, well, which is the good baby? They pick up the white baby. So what does this tell us? Even when we think we're being fair, we're not being fair. And Dr. Cameron Wedding, she's the first to tell us, she can't just give us all a blue pill and fix this all. You just have to be aware, and you just have to be consciously checking yourself on these things. And I invited that attorney to work to put together some more anecdotes like this that we can use, because this is probably the biggest issue, the biggest issue that we've got. And we've got to fix it, and it's going to take all of us to do that.
One of the things that we do have to deal with too, and in doing this, because the prosecutors have pretty much unfettered discretion as to what kids get charged where, and what charge you're going for, and what the sentence is. And we have the majority white prosecutors, and they have no standards or criteria. I mean, they don't have a chart in which you say, okay, this guideline, this kid has this kind of juvenile record, this kid has this. There are no guidelines, and so it's all gut. And often when you have, and I've talked to our prosecutor here who has a very harsh position on youth justice and does not believe publicly, does not believe in restorative justice, and talks about these children having no remorse and that we haven't seen the harsh look in their face. There are cultural biases, it's institutionalized, and with regard to what they believe they see of a young kid of color in terms of what the dynamics is, and also who represents that person. So there's a deep mix of class and race here. And so until we start addressing who our prosecutors are, and in this county pressing for a prosecutor that reflects our community mores, we're going to keep getting it.
One thing I would just add to that is there's a fair amount of research that shows that folks tend to overestimate the age of African American children. So a police, for example, there's a study of police officers, and they routinely estimate black children's age to be 2 to 4 years older than what it in fact is. So they're sort of blind to childhood in some way, I think, when it comes to black children. And I think that impacts who gets arrested and who gets treated more formally, and who gets a card for referral to a community-based counseling center when there's a problem in the family, and who gets taken to the detention facility, or at least the detention facility gets called, who gets charged. It's a really deeply ingrained problem.
So, on that note, actually, could I invite Dr. Keeney? Would you like to come up and join the?
I just wanted one quick comment on this, if I could.
Sure.
I agree with all the comments that have been made there. I think the implicit bias issue is definitely very much active in a variety of these settings. I think it's harder to correct at the enforcement point, because then you have the individual whose perceptions implicitly may ascribe greater dangerousness to someone who's a child if they're African American than if they're white. But I guess, again, this is not my area of expertise, but it seems to me where you should be able to much more readily correct that is at the prosecutorial discretion. Because in fact, you can overcome implicit bias by explicitly acknowledging it to yourself and then thinking it through, right? And so at that point, we ought to be able to overcome the implicit bias situation, or at least the mechanism exists to do it. I mean, obviously, prosecutors have a whole host of things that they're responding. There's a whole social context they're responding to as well, right? But in a sense, that the implicit bias stuff, I think, is extremely hard to overcome when you're in an aroused state, right? I mean, that's where it's the hardest to overcome. But that no longer applies, or ought not to apply, when you're dealing with it at the point of a prosecutorial decision. The other the other part of that is that there's another set of implicit biases, which is both race and class, which is that when you're thinking about alternatives to, sort of the whatever sanctions you're thinking about doing, when you're thinking of alternatives, and again, happens mostly at the prosecutorial level, the implicit assumption that some kids will have greater family and community resources that can rescue them from situations, and so you don't have any recourse, if you will, the assumption of a more stable context in which that kind of rehabilitation might occur outside of a set of sanctions, or with minimal sanctions or diversion programs and so forth. So I think it is a clearly problematic issue, but I think that we have to focus on where are the levers that we can change. And I think those are one of the areas. But I don't know, Deborah, you may know, but there's not as much of a huge push on the prosecutor side as there is on the sentencing side and so forth. And a lot of those decisions get made before it ever gets to that point, right?
I have a question here.
Sure.
I'm Georgia Campbell. My question is, I know that the state of Michigan itself did a lot of closing and downsizing of juvenile delinquency residential programs. My main question is, what do we see are used now as a component, community-based residential programs? What's out there now, and what should we look for as an excellent treatment program for our youth?
Well, I know, for example, in Wayne County, there has over the last decade or more been a real push to keep kids in their communities and in their families. Family treatments where the child and the family are being treated together. I don't know the names of specific programs, but they have had shown real success in keeping kids in the community and out of detention facilities and out of residential facilities. So the programs, functional family therapy and so forth, there are programs out there. There are not enough of them. There certainly needs to be more of them. And there need to be more creative in sort of how, in how they solve problems. But there are programs.
So one of the programs that you're talking about,
we have somebody over there.
To name it, MST, multisystemic therapy, you can look it up online. It's basically the concept is wraparound. It's very involved. It requires very dedicated teams. We have a limited number of slots available, but these are cases where somebody's really basically can be in the home on a moment's notice to address any issue that a juvenile might have, a young person might have. And so that's one of the programs. And the more of those kinds of programs, because those programs are expensive, but they're not as expensive as when you send a kid to placement for $200 a day. Right. So they are an answer, and we need more of them. And there's all kinds of funding issues with, we got this money, but only this money is for only kids if we're locking them up. And this money is if they're not locked up, and this is the small pot, and this is the big pot. And we have to change that way of thinking. And when we do, we'll be a lot more successful.
One other thing I would say is that something that Professor Keating said this morning that's really important, and that is delinquency desists, right? It is normative for kids to break the rules. And the research suggests that the best thing you can do with delinquents is nothing. Right? For most kids, the shoplifter, the kid who gets into the scrape, and every 15-year-old boy gets at some point into a fight over a 15-year-old girl. Right? Almost every boy. Right? If you do nothing, that is going to just stop. And we have this mentality in our system that every kid has to be sanctioned and monitored and punished. And the reality is that in this system, like in this county where I'm currently working, in Wayne County where I used to work, between an assault and battery when two kids get into a fist fight in a locker room at gym class, and the time 9 months later when they're actually charged with that, and a year and a half later when they're done with probation, first of all, the kid who's charged has forgotten what it is he's being consequented for, and the kid who he got in a fight with is now his best friend. They're talking to each other on social media, and the judge is ordering them not to do it. It's stupid. It makes no sense. Our system is absurd, right? I think that the thing that we should do most often is nothing.
We have 3 more people. Yep, so here, and then, okay. Okay.
Yeah, I just had a quick question, kind of a 2-part question. So for these juveniles that are currently going into the system and then coming out maybe 50 years later, what is their, I guess, I've heard rumors, I guess, on research that says like their brains are, or like their development is like similar. So if they go in when they're 17, spend 50 years in prison, and are 67 when they're released, they still kind of come out with that mindset of like a teenage mindset with all the development. So I guess first part, like what does that research look like, or is there any? And then the second question is, what do you do with these youth that go in when they're 17, coming out 50 years later? What can or should be done rehabilitatively on that end for these older adults now?
Well, just we have a number. So in Michigan, there were 363 children sentenced to life without possibility of parole. As a result of the Miller and then the Montgomery case, they all have an opportunity to be resentenced. So far, the last year, the resentencing started last August, and we now have 35 individuals who will be out by the end of this year. 29 are out right now, ranging in age, from a lot of them in their mid-50s. And so, no, I definitely would say that they are not 17-year-olds. They are, mature men and women coming out, but there is a developmental issue, having been in prison all this time, and in some ways infantized in the prisons, especially for the girls and women. And they don't know this world. I mean, it's overwhelming. They never had a job, most of them. They never drove. They're coming out without any of the skill sets that we have here, learning how to use a phone for the first time. So there's a deep need for assistance, and I'll just make a plug. There's a new fund that Dr. Sari has agreed to be an advisory board on. It's called the Youth Justice Fund Organization. And we're looking for social workers to help with some of the issues for youth, people who went in as youth, some coming out much older, some coming out still in their teens and 20s, with very little resources out there because people are being literally left at the door. There's no clothing, there's no money, there's no bus passes, there's no nothing. You have to pick people up literally, or they'll be arrested for vagrancy. So, there are, it's a deep need there, and I'm going to be making pitches to the school social work for some interns.
Great.
Just let me mention one thing too here. There are some groups of what we call returning citizens. All right, individuals who have been locked up, maybe they were adults when they went in, but there's a network of these individuals in Detroit. I've attended some of their events. They're phenomenal people. They're very proud of their efforts to reintegrate in the community. They recognize that they have challenges. So again, if you reach out to me, I could put you in touch with some of those groups.
Great.
Very quickly, I just wanted to say that in my 26 years as a social worker, I have found that prevention, it does work. It works. Years ago, I ran a prevention substance abuse program in some of the low-income neighborhoods, and to my surprise, I ran into one of my participants in the program. He's a black male in his early 20s now, and he's pretty successful. Not only that, he's gone back to that community, and he's running sports camps. So my question is, where is the juvenile justice system in terms of pushing funding for more prevention? Because it does work. It works.
Well, I know we've got some active diversion programs in Wayne County, and the more that we can do, the more we can keep kids out of the system. We have an excellent program called the STAND program for individuals challenged with substance abuse, and it's a very intensive program. You don't go into placement, and the way it works is you come in, you're charged, and you come in, and the prosecutor says, Your Honor, we're asking to dismiss this case without prejudice to allow the person to participate in this program. They have to show up every week. They have counseling. They have all kinds of programming. And if they successfully complete the program, their case, it just gets dismissed. It's done. And there is no record. They were never adjudicated. So we do need more of these programs, and the funding is a challenge on these things, but we do need more of it.
Okay. Go ahead.
Hi, I'm Kristen Meekhoff. I did graduate from U of M School of Social Work, and I've spoken at the UN. I've attended UN conferences, and I don't know, it's hard for me to understand how member states from around the world can come to resolutions in the UN. I've seen it happen. And then when something like this occurs, which is obviously, I know that you provided the pamphlet, why there's this stagnant progress in not only the thinking intellectually, but also being able to move it through simply one state. It's hard for me to understand it because I've seen it work at a global level.
Well, one of the problems, and I'm going to just tell you because I'm a member of the Michigan Probate Judges Association, and they opposed the last go-round on this because they want to make, we got a lot of judges outstate. It's not really so much my particular issue because I don't really deal with the programming directly in Detroit. I work on some projects, but I don't work on it as directly as some of the out county judges. But they are worried that, hey, we don't have money to treat these 17-year-olds, and you're not gonna dump these cases on us and not give us funding. So that's where the devil is in the details. And Jason is working on that issue, and other individuals. So we're working on, anytime you've got the state and the county, and the question is, the money right now is here to deal with these individuals because they're 17 and they go into the adult system and the state has to deal with them. And now we're talking about moving that to the county level. Well, you know, it's not like just snapping your fingers and saying, well, let's change it from 17 to 18. There are individuals that want to make sure that there are going to be the right resources for the counties to be able to address these individuals, and that's one of the issues that's one of the reasons why this is taking so long.
2 points real quick. One is, our criminal justice system is incredibly mean. We are just mean. Just stop and think about what we're talking about here. It is irrational to send 17-year-olds to the adult system. It is irrational to send 15-year-olds to the adult system. But we do it. Why do we do it? Because we want to punish. Because we're mean. And number two, if you did nothing with the kid who shoplifts, or you diverted them, or you had some sort of a community-based program, and you could focus your resources on the kids who really are committing real crimes and serious crimes, you'd see a lot different, I think, in terms of the money. You know, there's in your packet, there's the executive summary from the Justice Policy Institute. I know someone's going to speak this afternoon about that. But this idea that you're going to spend more money is just not borne out by experience. States have actually saved money, some states, in terms of raising the age. And in some states, while the expenditures have gone up, they've gone up nothing like the wild, sort of tens and 30s and 40s and 50s of millions of dollars more. That's just not true. And the truth is that a lot of times you save money because you can treat most of these kids in the community that need it. We could stop prosecuting kids and hauling them into court and paying for lawyers and paying for probation officers. And what we do in this county is then we tag the kid, you got to pay a bunch of fees to the court, several $100s, and then we keep you on probation for months because the kid is from a poor family and can't pay it anyway, right? We're fighting that battle right now. I see the probation officers are all laughing because I've been on this bandwagon for a while here in Washtenaw County. right? We're mean. It's just meanness. And we got to stop doing that way. We just can't, there's no compassion in this system. There is no empathy. There's no thought that there before the grace of God go I or my child.
Got a
You
question
really,
here?
you really do have to court watch. I mean, you really do have to go and see what is happening. And you would be actually just stunned. You're saying, really? That's a misdemeanor? You're charging that kid with a misdemeanor for that? You know, and some of the behavior that's going and the sort of going on in the prosecutorial push of exercise of power, it's pretty stunning, even in this. Well, particularly it's stunning to me in this community.
Yeah, here, I'll give you this. I hate to do this too because I know Deborah said she hates to talk about war stories, but here's a quick little war story, right? This is what I'm talking about. A 14-year-old girl gets into a fight with her, an argument, not a fist fight, but an argument with her 13-year-old sister when they're cleaning the bathroom. And the 14-year-old sprays the 13-year-old with scrubbing bubbles. And she is charged with a felony in this county. A felony. Assault with intent with a dangerous weapon. I had a kid charged with a 10-year felony because he stole a candy bar from a vending machine in the cafeteria at Saline High School. That is just ridiculous. It's absurd. It's mean. There's just no point of it. And he comes to me when he's 19 years old and he's trying to go to community college and he's trying to work and he can't get a job in a factory because they look up his criminal record and he's got a record for felony theft. Because he never had a lawyer, and he pled guilty to a felony, a 10-year felony of larceny from a vending machine for stealing a candy bar, a Snickers bar. That is ridiculous.
I have one last question here.
Yes, he's elected.
I have a comment, actually.
But we have one more question, then we got to wrap up because as we see, Frank is getting hangry, and we have others here. We've got to move.
Okay, first panel, thank you so much for your expertise. And I want to go back about 10 minutes to something that Dr. Keating said. And as a social worker, I'm hypersensitive to some of this language. And I work as the social worker, school social worker in the county juvenile detention center. The comment you made that I think was a fairly innocuous comment about boys will fight with boys over girls. And I don't want that to slide by and be normalized, because that is part of our cultural story. This idea of violence to a certain extent is okay, especially between boys if it's over a girl. So I want us to just keep that in mind around gender and power. The other comment is this idea that if we do nothing, I want to say that all the research that I understand shows that kids don't get in trouble and then they have trouble in school. They have trouble in school and then they're out on the streets committing the crimes during the day when they should be in school. So instead of nothing, I would say the more efforts that schools can do, and we have task force in Washtenaw County right now working on this, to reduce truancy, to keep kids in school, to follow up with parents, and then of course the funding to support the parents who are in desperate need of help as much as the kids are. And thank you.
So let me just remind us, we have lunch here. We have to hurry because the hungry law students are going to go take our food from us. But it's out in the hallway here. And we'll be coming back at 1 o'clock. Reminder that this afternoon we have another panel that's going to look at data and all. And we'll also be involved in some advocacy discussions. And then end the day with what we can do to be involved in this issue. So we'll see you at 1 o'clock.